Hi guys, I'm Virgil Breeden. This is my 6th post concerning the corruption in Mississippi courts and the war I've started with them. Today is May the 12th, 2025. First, I apologize that I'm a couple of days late on this post. I had a minor surgical procedure last week, and you guys know that I'm trying to kind of put a life back together after being locked up for 18 years in the Mississippi prison system. So please forgive me if I am just a couple of days late. I will try to be a little more consistent in the future. Sometime probably toward the end of next week, I will be going to Jackson. I'll be going to the Mississippi Supreme Court. I don't have the funds to go more than once this month. Things are obviously a little tight. But I'm going to go in and ask to be able to come back and speak before the court. Well, you guys already know what's coming there, and I suspect they do too. There's some of them that know my name, and they know that I stand strictly on the Constitution, and I'm going to point out the fact that they don't. I'm going to step outside for a few minutes. It's a little cloudy. May wind up having to come back in, but I'd like to do just a little bit of the video out there in the fresh air. So I'll be out there in just a minute and continue. I realize I probably look a little bit like Gandalf the Magician with this hat on, but it's sprinkling out here a little bit, and I'm about to have to go back inside to put everything together for this video. We're going to talk about one of the most unconstitutional cases in the history of Mississippi. Today it's a 1995 case. It is the case of Matthew Brandow v. State. And when I get inside, I'll give you some more specifics on how you can look it up yourself. The case was heard before Prather, Banks, and Smith, and the opinion was written by Judge Smith. I was told yesterday that I should not call a judge on the Mississippi Supreme Court an idiot. Well, all three of these are freaking idiots. Not only that, they acted unconstitutionally and apparently without even knowing what the Constitution says and how it's put together. Well, you can bet on the fact that I'm going to explain it to them. And I promise you, I give them an open invitation to come and sit down in front of me, one, two, or all three of them, and I will make them look like a damn fool, especially in this case. I apologize for the language. I'm fixing to go inside. I'll mention a couple of other things real quick, and then we'll get straight to Brandow v. State. And well, you guys know that I'm kind of out in the middle of nowhere, and this kind of gives you an idea of just how far out in the middle of nowhere I am. But this is my kind of place, and I love it. So let's go inside and talk about Brandow. All right, guys, just got back in. I admit that I look a little more bedraggled today than usual. I apologize. I've been running a lot. Trying to restart a life at 74 years of age is a little bit difficult. I do have a total knee replacement coming up a week from today. That will be next Monday. But that won't keep me down very long. They are going to do that Monday afternoon, so unfortunately I'm going to have to stay overnight. But rest assured that just as soon as I wake up, I will get up and walk. And sometime before the end of the week, I'll get to Jackson, as I said, and approach the Mississippi Supreme Court. But we're back to Brandow v. State, and the absolute lack of constitutionality in the ruling. Back in 1995, Matthew Brandow sent a motion for reconsideration to the courts. Brandow presented a number of issues in his case. You can see those. I'm going to put the information up so that you can pull up the case and read it. Most of those were kind of touch and go. There was one of them in particular which was not a viable issue, but the thing that the court tried to do was protect the prosecuting attorneys who made an egregious error, and this is what judges do. We're going to look at a single issue, and that has to do with the Constitution of the state of Mississippi. The case of Matthew Brandow was opined, as I said, or the opinion was scripted by Judge Smith. And what happened in the case What they had to protect was the fact that Brandau's indictment left off a constitutionally required statement. That statement comes at the end of an indictment, and it says that what comes before must be held as being, and I quote, against the peace and dignity of the state. End of quote. It doesn't even say the state of Mississippi, but it says whatever you have done has to be against the peace and dignity of the state. Now, that's something that was so brilliantly put into our Constitution, because the Founding Fathers realized that you could do a lot of things, but until you actually did something which affected the peace and dignity of the state, it could not be held against you as a crime. This is the reason, for example, that statement is the reason that a prosecuting attorney does not have to drop a case after you have presented yourself, sworn out a complaint, even if you go back and say, well, I didn't really mean it, that's not what happened, I want to take it back, I feel sorry for the person, whatever you might say. Prosecuting attorneys hate to have anything recanted, even if you come back and you tell the truth. Now, there are some times, admittedly, when they will allow a case to be dropped, but they don't have to. Once you've made the complaint, once it falls under one of the Mississippi statutes, and once it is established that you have acted against the peace and dignity of the state, then the prosecuting attorney can take it and run with it no matter what you say. That, again, was a brilliant piece of forethought on the part of our forefathers, the Founding Fathers, the individuals who put the Constitution together back in 1890. The constitutional part of Matthew Brandau's case comes about because his indictment did not end in those words. And here is where it gets interesting, and here's where the court did some dipsy doodles that they had no right whatsoever to do. Matthew Brandau, or his attorney, whoever turned in the motion for reconsideration, stated that having those words at the end of his indictment was, in essence, a right, that he had that right to have those words there. Wrong, Maynard. It is not a right. The state of Mississippi, the Constitution thereof, gives you Article 3. Well, do you know what Article 3 is all about? It's called the Bill of Rights. Now, this is where Article 3 starts in the Mississippi Constitution. There are a number of things here which are very important to you as individuals, because these are your rights as given by the Constitution. But what about these rights? Why is this important in this particular situation? Well, it's important because a right can be waived. If, for example, a police officer arrests you and says you have the right to remain silent, you don't have to remain silent. You can waive that right. You can give up that right. But the fact that the Constitution says that those words against the peace and dignity of the state must be at the end of an indictment is not a right. So where are we going? The Mississippi system of justice is based on two primary mantras, two premises that the judges and all of the lawyers and all of the prosecutors in the state hold sacred. They're not written down anywhere, but this is kind of what they go by. The first one is simple. Judges protect judges. Judges protect lawyers. Lawyers protect judges, and lawyers protect lawyers. The second one is equally as simple. When it comes to a criminal petition before the court, deny at all cost. no matter what it takes, no matter how unconstitutional you have to be. And when it comes to protecting the Mississippi Department of Corrections from a lawsuit, deny at all cost. It doesn't matter how much of an idiot you have to look like or actually become. Now, I want to read something to you. This comes out of our Constitution, and we'll see where it comes from in just a moment. This is section 169 under the Judiciary, Article 6. And here's what it says. The style of all process shall be, quote, the state of Mississippi, close quote. And all prosecutions shall be carried out in the name and by authority of the, quote, state of Mississippi, close quote. And all indictments shall conclude, quote, against the peace and dignity of the state, close quote. This is not a right. It does not come under Article 3 of the Bill of Rights. This is a constitutional freaking command that the three judges on this panel from the en-banc opinion of the court just threw away. They argued that, well, if Brandow says it's a right, then it's waivable. You can't do that because they should have known that this is not a right. It does not come under the Bill of Rights. This is a direct constitutional command. You can't just make it go away. You can't figure out some way to make it sound good, to flit and flutter and do some bull crap to it. It is a constitutional command. They should have recognized that. Maybe they did. Maybe they were, just as I said, legal idiots. But that is not a right. That's a constitutional command. Now, what this means is that they had to protect the prosecutor that put the indictment together against Matthew Brandow. Brandow, from the looks of everything that was written, may indeed have been guilty of a crime. But they let the prosecutor get away with what he should never have gotten away with. This is not trying to help somebody based on a technicality. This is making the people who prosecute in the state of Mississippi actually go back and learn the law. Pay attention to what they're doing. Unfortunately, there is no prosecutor school. There's no judge's school. You just get elected. If you get up in front of somebody and say, well, I'm going to be hard on crime, and then you get elected, and you are hard on crime, but you're even harder on the Constitution of the state of Mississippi. All we have to do is begin to rule constitutionally, and you better believe the prosecutors are going to begin to fall in line. They're going to go back and open up some books and begin to study what they need to be studying, rather than having these judges come in here and twist the law to suit their own petty, personal, treacherous, treasonous, you heard the word I used, didn't you? Treasonous agenda to protect them and to make sure that this guy didn't get a chance to go back to court. They could have sent him back to court. They could have given the prosecutor the opportunity to do it right. Guess what they did? They just threw it out the window. They took a constitutional command and made fun of it and demeaned it and belittled it and stepped on it and spit on it. Did they just not know what they were doing? Well, obviously they don't. But the other possibility is that they did that on purpose, that Smith wrote that out knowing that he was absolutely and totally wrong. The work of a legal idiot. Now, the crux of what I'm trying to say is that because this was absolutely constitutional, the court had no choice but to rule in Brandow's favor. It's not like they were given an opportunity to play games the way they tried to play. This is a constitutional command. And when you break that command, if you're a judge and you do so knowingly, does that constitute treason? Well, it certainly constitutes treachery. And this is what we're faced with. I'm going to mention a case from, I believe it was Texas, Coxby State. And in that case, there was a brilliant statement about a little thing called an ipse dixit, a saying, if you will. But that the judges were bound to follow the voice of the people that founded this state, the people that founded this country, the brilliant individuals who wrote our constitutions and made them so simple and so clear. It doesn't get any more clear than what I just read you, and it's not a right because it's found under Article 6, Section 169 in the Mississippi Constitution. Please look it up. I'm going to try and put a link to Brandau on this video. If I can figure out how to do that. I think I've kind of halfway got it figured out. You guys know I'm still learning about all of this. But this case is tragic, and if there are any questions, please get with me and let me know. You already have my email. It's docv.jr@gmail.com. That's docv.jr@gmail.com. It's in one of my other videos. But if you have any questions about this, please let me know. If I have to expand on it some more, I'll be more than pleased to. But I want to keep this down to being as brief as possible. I'm so grateful for the incredible support I've had so far. It seems like everybody that I talk to understands. They've been through things with the court system. Their family's been through things with the court system. And they're tired of the treachery. I've said before, we have to have a system. There are people who cannot live within the confines of societal values, and they have to be dealt with. And I have no problem with that, none whatsoever. But Mississippi is not hard on crime. Mississippi's hard on Mississippi citizens. That's going on every day because of this corruption. And if you don't think that that case represents constitutional corruption, then I have no earthly idea how to explain this to you. This goes on time and time again. We're going to step up to a little more modern time, and we're going to look at the case of one Mr. Thomas Flint out of Hattiesburg. What happened to him was you won't believe it. I'll show you the facts. I could tell you right now, but you'd say, that crazy old man's lying. That can't happen to anybody. Well, it did. And we're going to talk about that case. We're going to talk about some others too. I will not back down from this. I'll be in the Capitol as soon as possible. Please say a prayer for me. I'm having my leg operated on Monday. And please, guys, send me a message. Tell me your stories. Let me know what's going on with you, and know that I am so very grateful, unbelievably grateful for the support I've been given so far. Give me a subscribe. Give me a like. Let's get this out to as many people as possible. Thank you all. God bless you all, and good night.